Welcome to Courtline Media, where every case has a story and every verdict changes lives. Let's step inside the courtroom.
All right, today is plea deadline date.
Yes, Judge. At this time, the state has made us a slightly different offer. We are not inclined to accept that offer at this time, so we would just like a jury trial setting.
All right. State, how long do you expect this trial to last?
What is this, Judge?
It is Joe Rodriguez.
This one, including jury selection, probably about 3 days.
All right, Ms. Ferguson, I need a jury trial date, 3 days. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, sir.
All right. And then Lindsay, check with the jail to make sure they haven't changed the clothing exchange.
Yes,
For
ma'am.
now, it's within 72 hours.
Okay. Yes, Judge.
Judge, I can do the April 7th.
All right, your jury trial date will be April 7th. If anything opens up sooner than that, we'll try to have you brought over sooner. All right, do you have any questions? All right, thank you.
Thank you, Judge.
Thank you, Judge.
You do your thing.
Okay. And
Derek was in.
yes.
Judge, whenever you're ready.
All right, just give me a moment. All right, who's next?
Derek Lopez, page 1, 4 down.
Derek Lopez.
Present for him, Your Honor. He's the one that turned himself in on a warrant yesterday, so he is still going through booking at the jail, so he's not present for that reason.
All right, Ms. Ferguson, recall this for Thursday.
February 5th.
Yes,
Okay, thank you, Judge.
you're welcome. So usually when someone turns himself into the jail, it takes a long time to go through booking. And then once they go through booking in their process, then they can get sent here by the court. But what ends up happening too, it takes longer to go through booking if it's your first arrest because they have to generate a SID number for you. And SID numbers are supposed to be unique numbers. So nobody's supposed to have the same SID number. And if your SID number is very low, that means you've been in the system for a long time. I once had a client, their SID number was 3 numbers. And now if you look at people's SID numbers, it is like 7 numbers. So, yeah.
Awesome.
All right, who's next?
Is Kevin Robinson, page 9, 1 down.
Kevin Robinson.
Morning, Judge.
Good morning. How's it going?
Pretty good. New intern for the court.
Yes, this is Paris. This is Renee. Make sure you speak with him.
Nice to meet you.
All right, so why don't I have the motion to revoke? Are you all proceed? It's Kevin Robinson. That's okay.
With regard to the motion, Judge,
Mhm.
I know this is the first setting on this, Your Honor. They're alleging new number 1 on there.
Thank you.
I do need to look further into the protective order, as well as the videos associated with this, to see if they comport with the report, Judge. And I believe that the state is wanting to also look into a more detailed version of the criminal history before proceeding on a possible resolution, Your Honor. So we're asking for a reset of this matter.
All right, what I'm going to do is I'm going to set it for a contested hearing in 14 days. And either it's going to be contested or it's not.
Yes, Your Honor.
Ms. Ferguson, I need a 14-day reset.
May I propose a date that's in line? I think it's maybe a few days past that, February 19th. It's a Thursday. It's my schedule. That's
Sure.
something the court would work with.
February 19th. Is that good, Norma?
Yes, ma'am.
All right, so we'll set it for a contested hearing at that time. If it turns out it's not contested, please notify the court and the state.
Will do, Your Honor.
All right, you have any questions? All right, just have a seat. They'll give you your reset form, and once you sign it, you're excused. Thank you. All right, who's next?
Lindsay Church, ready to reapproach Judge.
I'm Mr. Bassett, director.
Yes. I'm ready. Let's get in. All right. We're on the record in 2017 CR 5709 State versus Michael Bassett. Can I have parties announced?
Lauren Espinoza for the state.
Lindsay Shaw for Mr. Bassett.
And are you Mr. Bassett?
Yes, I am.
All right. You entered a plea on October 30th, a plea of true to violations 2, 2, 2, 2, 5, and 5.
Yes, sir.
And we had this case recalled for today, and you were placed on GPS, partial for medical and employment. The court was presented with letters to review by the defense with no objections from the state. Is there any other evidence to be presented to the court? State?
No, Your Honor, we just have prior criminal history if the court wishes to know that.
Defense?
Just, I re-urge some of the argument that was made at our last setting, Your Honor. No other evidence.
All right. Any objections to the court reviewing the court summary?
No, Your Honor.
No, Judge.
Let me see.
I actually have it.
Thank you. All right, here. Thank you. All right, state you're recommending revocation. How much time are you requesting?
We are requesting revocation, judge, and sentencing for 5 years in the prison.
All right. And defense, what are you requesting?
Well, Judge, as the court's aware, this probation expired in 2022. But I guess what we're requesting, Judge, and if the court would recall the testimony from my client in October, he had a warrant for many years. However, he didn't pick up other cases. He was gainfully employed. He owns a landscaping company. He takes care of his 19-year-old daughter who has terminal cancer. She receives treatments through his VA benefits. It's through the TRICARE program. And I can offer, I think he might have something else he would like to say to the court, but he has a lot of people that care about him and that he supports, and he's not standing before the court and not taking responsibility. He's fully aware that he made the wrong decision, but that he is asking for forgiveness from the court and to give him another opportunity.
And did you provide the medical information to the state?
I did not do that. I can offer through my client, if the court wants to hear about what kind of conditions.
No, I think he needs to give medical information to the state, and then who knows? Maybe the state will ask for something other than revocation. But we were supposed to come back here for part of the things the court wanted was medical.
I didn't know that was requested, but yes, I can get that now.
Right? That needs to be done today.
Yes, sir.
So we'll recess till 1:30, and you need to come back at 1:30 with that information.
Yes, ma'am. Thank you, Judge.
Okay, thank you. Who's next?
Christian Garcia, page 10, one down.
All right. So he's scheduled for jury trial on February 17th.
That's correct, Judge.
Right. I'll have to make a correction because I see where it says February 17th, 2025. I'm like, why hasn't this happened?
Although this is a case we've had back and forth about discovery with juvenile records many times, and
Oh, yes.
that's still unresolved.
I thought they had a hearing or something over
We had
there.
a hearing, the judge allowed us access to one file. And then when we requested, they say we can't find the file under that file number. Well, we can't get file numbers or case numbers because we can't get access. Recently, Megan provided me with a list of about 10 or 15 SAPD numbers in the hopes that getting those might get us what we had been asking for at juvenile. They wouldn't give us. I put in the request to the city. I'm waiting for a response. So, although I think the response is going to be, no, you can't have it. I'm almost sure.
It makes no sense, but
Well, it's because they're juvenile records. But anyway, we're here for another tangent issue. I've asked for a bench warrant for the co-defendant juvenile.
mhm.
And I didn't want you to say, why are you asking me on trial date for that? So I'm doing it today.
Okay.
And I don't know where he is. For some reason, he's a juvenile.
All right, state, he's saying that he wants to bench warrant a witness and it's a juvenile. Do y'all have any access or somebody where he is located?
I can try to ask the juvenile prosecutor. I would like to represent to the court that, I've been doing everything that I can to help Mr. Martinez get this evidence, but I don't have access to it myself.
All right, we can go on the record.
Okay.
The court is calling 2024 CR 008-124, 2024 CR 008-173, 2025 CR 007-834, State versus Christian Allen Ruiz Garcia. Can I have parties announced?
Megan Galloway for the state.
Raymond Martinez from Mr. Garcia.
And are you Mr. Garcia?
Yes, ma'am.
All right, so we were discussing off record issues with discovery, and that's related to a juvenile, and you're wanting to review the juvenile's file.
Correct.
All right, so the record can be clear. If you can explain for the record or state on the record why you feel that's material that you have a chance to view all of those records.
Okay, Judge. And if you don't mind, I'm going to go backwards a little bit to prior hearings we've had in this court. As you recall, this court tried to facilitate that scenario by setting up a Zoom hearing where the juvenile prosecutors appeared on the record on Zoom and told this court directly in no uncertain terms, you can't have those files and you can't see those files. He just said no. Said, okay. And then I later learned that I could petition the juvenile judge who handled those cases and ask his permission. He gave us permission to look at the one file that coincided with my client because the juvenile was accused of doing like 15 aggravated robberies. My client was only involved in one episode, right? Well, first of all, allegedly. The problem is the point of me looking at those other files is we've alleged a defense of duress, and we've explained to the state why we've done that, and we're all on the same page about why that might be the case. So in order to flesh out my client's state of mind and whether he was under duress, I wanted to be able to demonstrate to the jury what this other kid was doing, what he was capable of, whether he was carrying a weapon, whether he shot everybody, all those different things that would give some context to why my client felt like compelled to participate in the limited manner in which he did. Problem is, it gave me access to the one file that I do have access to because I have access to his files. All those others, they said no. So not only did they tell you no, the juvenile judges told me no. They've told Ms. Galloway no, and they're going to continue. I think they're going to continue to tell her no. But today was me continuing to perfect my record in regards of all the different places I've been stonewalled. My hope in bringing the co-defendant, the juvenile, is for him to tell the jury, no, I don't know Mr. Garcia. No, we didn't plan this together. We didn't go to school together. We're not friends. To further show this, he's not a party to this case.
Let me ask you, does anyone know who was the juvenile's defense attorney?
And we've spoken to him, Judge. Abe Garza was a lawyer.
Okay.
And he has not wanted to be forthright in disclosing. I think for the same reason. He feels like if the court can't disclose it, I as his attorney shouldn't be doing that. And so he's kind of politely stonewalled as well. So yes.
Well, is he still the attorney of record or has he withdrawn? Because if you are able to bench warrant him or her, they're going to need an attorney appointed to represent them.
I think he appeared at the hearing in front of the juvenile judge on our request for discovery. So yes, I would say he probably still is. The hearing that we had a month or two, well, before the holidays, it's been a while, where we asked the juvenile judge to give us access. Yeah, he was there at that hearing.
All right, let's do this. Let's go off the record briefly. If someone has Abe Garza's number and see if he can appear maybe by Zoom.
No, Judge, if I'd have been a little quicker, I saw him earlier.
Yeah.
Might have even been in here. But
Oh, let's
we'll
call
try.
and see.
Okay.
All right, thank you. All right, who's next?
Thank you, Your Honor.
You're welcome.
I don't think they're ready. Judge, the purpose of swearing in the defendant.
Okay.
Yeah. Okay, sorry.
All right. The parties on Jonathan Navarro. You okay?
No, he doesn't have any drug issues.
It would be, February, March, March 12th.
March 12th? All right, we will see you then.
Sorry.
At that time, I'll make a decision on your application based upon whatever evidence is presented to the court. All right, thank you.
Is that a PSI and CAP?
No, just PSI.
Okay.
Thank you.
Your Honor, may I approach?
Yes.
If this is your signature, please.
Sure.
Thank you.
Have a great one.
Thank you, you too.
Is there anyone else? Oh, yeah. Can I have that back, please? I think I attached my docket to it.
Yeah. Yeah.
And what? There he is. All right, anyone else ready?
Yes, Judge, we have page 1, second down. First.
Constance Sinwell.
Yes, Judge, we're ready. She's in.
Hello. Yes.
Yes, Judge, you brought us back for a status on this is a case where we're working on a plea, but the prosecutor had to go upstairs.
Mhm.
We're super close. Trial date, we have a trial in a few weeks. Well, everyone's ready, but I think we might be able to get this resolved, with counteroffer going upstairs. So I don't know if you want to bring us back maybe next Thursday and for a plea. I'm pretty certain we're going to have a plea that day.
All right, Norma.
Yes.
Recall this for February 5th for a plea.
You did.
Thank you.
Thank you, Judge.
You're welcome.
We do everything.
Christopher Martinez. Excuse me, state. State.
Yes, Your Honor.
I'm sorry, it's family violence. Jonathan Navarro, the aggravated assault with a deadly weapon. What's happening with that case?
That case will be resolved, Your Honor.
Okay. That's going to be on the March 12th as well. No problem. And what page is Martinez on?
Well, page 5. Too bad.
All right, the court is calling 2025 CR 011-500 State versus Christopher Ray Martinez. Can I have parties announced?
Lauren Espinoza for the state.
Orlando Gaston for defense.
And are you Mr. Martinez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it? Defense, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the punishment enhancement and also proceed on the lesser included offense of possession of a controlled substance, PG 1 to 4 grams.
Any objection?
No, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1. 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea, the court does not have to follow your plea. If the court gives you more than you bargained for, the fact that you enter the plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, the state is waiving the enhancement. They're proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, 1 to 4 grams. Punishment is to be assessed at 3 years in the prison. There's a $1,200 fine. State recommends community supervision. Did you understand that to be your plea?
Yes, I did, Your Honor.
Defense?
It is, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, regular random UAs, and the DOEP course. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objection.
Did you review the waiver and state you may be excused?
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just that we ask that you follow the agreement, Judge.
All right, so how often have you been using?
I had a history, when I was younger. I'm not, I don't be using.
Well, I mean, as early as whatever this case is.
I will say, Judge, that I have spoken with my client. He is motivated to attend outpatient treatment. If inpatient treatment is ordered, he is willing to go to, he was asking that he go to lifetime recovery. He did find a job. He is currently working and he wants to enroll in SAC. And so I have discussed, was that? Oh, he currently enrolled in SAC. And so he is motivated for treatment. He does acknowledge that he has used in the past. I don't know recently.
But not since he was young.
I don't
like, because how old
I don't
are you?
believe that's true.
Okay. So here's the thing. You need to be honest with me, and let me just tell you why you need to be honest with me. Because I'm trying to put conditions so you can be successful. I take no joy in sending people to prison, but your attorney will tell you I have sent people to prison. So if you tell me I don't have a drug problem, I don't use, you know what's going to end up happening? I'm going to send you out the door on your way, and don't come back to me testing positive for drugs. You understand?
I understand.
So I'm trying to figure out what can help you.
Yes, I am currently trying to seek treatment. I was hoping to find outpatient because of school and work. But I do have, like I said, I do have a history of drug use. But I was trying to insinuate that because of like past, I've gone through different stages where I am trying to stay clean and not relapse.
Okay. So what are you studying at?
Social work.
Okay. Awesome.
Yes, I'm trying to help change, from the other side of the field, the best way I can.
All right, so do you have any children?
I don't have any children.
Okay, so who's your support system?
I have family, parents, and I have a partner.
Okay, so do you live with your partner or not?
My partner, yes.
Okay, and is there any drug use with your partner?
No.
Okay, well, if you're gonna be in that relationship, you're gonna have to meet your partner where they are, right? So this is what the court is gonna do. There's a $1,200 fine. Time and money will run concurrently. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release. There's to be no employment as a home healthcare provider with minors. TAP evaluation out of custody. Do not miss that TAP evaluation. If you do, that's going to be a violation of your probation. They're going to slide across my desk a motion to revoke. You understand? Sentence you to 3 years in the prison, suspended and probated for 3 years. There's to be 120 hours of community service restitution. 20 of those hours will be, let me not do that. I'm going to deduct 1 hour community service restitution for every sober support meeting you complete.
Okay.
And then there's going to be field visits 1 time per month for 6 months. And probation, follow the TEP recommendations, but if they're asking for inpatient treatment, we'll start with outpatient treatment. And do a referral to Lifetime Recovery. Maybe they'll accept him. Probation, is there anything else?
A referral for Lifetime Recovery inpatient.
Let's start with outpatient and see how it goes. Or can he just go over to Lifetime Recovery?
Yes.
All right, so just make sure you go over to Lifetime Recovery. You understand? All right, thank you, probation. Is there anything else?
Yes, Sharon, before I go off the record, I have a dismissal plea for that.
Okay.
Related to this defendant.
Thank you. Is there anything else that you need in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you, this is a PF, that goes with whomever it goes with. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back to me. Whatever you do, do not disappear. You understand? All right, good luck to you.
Thank you.
Thank you,
You're
Judge.
welcome.
Be excused.
Yes.
It's 2 lines.
Anything else? No. You better look. If I have it.
Approach, Judge.
Yes.
Mr. Garza did not respond to my text or my phone call, Judge. I was wondering if maybe he has a setting in here the next day or 2 or 3.
All right, let's look and see.
Yeah.
All right, and we're going to take a recess.
If we find one, can I set it that day?
No, we're going to talk to you, but
Okay.
we're going to take a recess.